I'd like to reserve 3 minutes.
3 minutes,
for
Mr.
rebuttal.
Kline.
Thank you very
All
much.
right, thank you.
May it please the court, my name is Jonathan Kline. I represent the appellant in this case, together with Associate Counsel Mr. Stephen Thompson from our firm. The appellant is Lake Success Management, HOA, LLC, and I'll refer to the appellant as Lake Success from here and after. Also in the brief, it's referred to as Lake Success. This is an intervention case stemming from a rule of civil procedure, but I'd like to briefly go over the facts. A bank, Deutsche Bank, filed foreclosure against a homeowner, and my client took quitclaim deed, the rights and interest to the property of the property, which is the subject matter of the litigation, from the original mortgagor homeowner.
Mr. Kline, I'm sorry, there's a fact I'm curious about which wasn't mentioned in the briefs. Had the HOA, I imagine that this homeowner was delinquent in assessments.
I think it was a bank foreclosure.
I understand that there's an underlying bank foreclosure by the appellee. My question is, the HOA took title, but was this title in lieu of a foreclosure? Was there a pending foreclosure by the homeowners association for unpaid assessments at the time?
The name of the appellant is confusing because they call themselves HOA, but they're not the homeowners association for this particular subdivision.
Oh, okay.
Yeah, it's confusing, but that's their corporate name.
Okay.
that They take title under. Subsequent to them taking title within 3 months, and they filed a motion to intervene. And after that, it was heard before the trial court, and it was denied. A timely motion for rehearing was served pursuant to 1.530B, and it was subsequently denied. And this appeal stems from that motion, the underlying motion to intervene in its rehearing.
Let me ask you, would you agree as the appellant, you've got the burden to demonstrate that there was error by the trial court?
Yes.
Right? Okay. If in your motion to intervene, you don't state any of the factors outlined in the two-pronged test of Union Central. So if that's not in your motion, why should, and we don't have a transcript of the hearing, why should we find that there's error by the trial court?
Because that two-pronged test in Union Central is a discretionary test, which is determined before facts before the court. And I think without having a record of the decision from the trial court, you can simply look at the underlying facts and the admission in the response or the objection served by the appellants to our motion to intervene. They actually agree that we took title by quitclaim deed. It's agreed. It's a fact that's before the court that can't be ignored.
But don't we have a bit of a problem without the transcript of knowing what might have been argued or abandoned or whatever in argument before the court?
No, I don't think so, because if you look at the two-prong test in Union Central, the first prong is it stems from a direct immediate character. It's a direct immediate character test, and the first prong is the interest asserted by the intervening party appropriate to support intervention, such as a right could be either gained or lost during the pendency of the litigation. And by clearly owning a property, which is the subject matter of the litigation, I think that the court can determine that that absolutely is answered in the affirmative.
Okay, well, go ahead, Judge.
Oh, I was just going to say, in Miracle House, the Supreme Court held that intervention is proper to avoid irreparable injury and also a multiplicity of suits. Would that have been the case here? Would there have been irreparable injury and additional suits flowing from failure to allow intervention in this case?
Absolutely. That's the public policy that was injected by the Florida Supreme Court in the Miracle House case in 1957. There would be absolutely a multiplicity of lawsuits. There would be. How? Because our client owns the property. They have a right to assert their interest in the property pursuant to the rights and interests from the quitclaim deed received from the previous owner.
What about the fact that you took subject to
It's correct, you're correct.
I mean, anyone who buys, and there was a list pendants, and there's no question here that there was a list pendants in place when your client took a quitclaim deed to the property.
That is correct.
So they are on notice that this property is the subject of litigation, and for, you know, decades, we understand that if you buy something with a list pendants, you are subjecting yourself to that judgment.
The judgment wasn't in place, it was simply litigation pending.
Right,
And
and
if-
the eventual outcome of that litigation will affect you.
we agree that we would take it subject to the litigation, but yet we're still allowed to intervene pursuant to the rule, which is current rule 1.230. Anyone claiming an interest in litigation may at any time be permitted to assert his right by intervention. But the intervention shall be in subordination to, just as you said, and in recognition of the propriety of the main proceeding,
Okay.
unless otherwise directed or ordered by the court.
And let me ask you one other question that's interesting. There seems to be divergent case law on the issue, because I think if we go back, it was intervention of someone who buys with a list pendants was not permitted. I think that subsequent, there's been some cases that have permitted intervention. Given the fact that the case law now is, that there's case law holding both ways, is it not a discretionary decision by that trial judge?
Yes, but the discretionary decision is confined to the rules before the court in the cases, the Supreme Court cases, and the two-prong test. And
So let me ask a question along those lines. You know, I agree that Providence and Brickell stand for the proposition that if a person or entity will be affected by the outcome of the suit, has issues, other parties may not have an incentive to litigate vigorously, then intervention should be permitted, okay? I'm trying to understand what are the interests that your client has that the previous property owner didn't have?
they have, I mean, that they didn't have.
Right, because, you know, what strikes me is, it seems like by the quitclaim deed, and I think Judge Perez might have been alluding to this as well, you kind of step into the shoes of the former owner.
Correct.
And if the former owner has basically not raised defenses or anything like that, it sounds like what you're saying, well, because they dropped the ball, we now want to pick it up and run with it. But it strikes me that if the litigation's been going on and the trial judge reaches the conclusion that this is just a delay tactic, whatever rights the former property owner had were waived because they never asserted them before now, isn't that part of the discretion the court has in saying, we're not going to prolong this litigation to now allow you to raise issues the former owner didn't?
No, I disagree, because you're allowed an intervention, you take the proceedings at the time that the court allowed intervention. And at the time, in this case, I think if you look at the docket, we could have filed affirmative defenses, we could have answered the complaint, and we could have defended the foreclosure suit. Like,
Then you also could have gotten into the case under Rule 1.260C, which allows a substitution of parties when there's been a transfer of interest.
however,
And what strikes me is strategically, your client didn't pursue that because, again, that then puts them into the shoes of the prior owner, and if that's all been waived or whatever, how they litigated the case before doesn't allow the successor to come back and unravel all of that. It strikes me, it's within the discretion of the trial judge to say, I see what you're doing, but I'm not going to allow it.
well, you still have to look at the test then. The test in the Union Central Life Insurance versus Carlisle case states it's a two-pronged test. The first prong is, will you stand to gain or lose in the litigation? And I think it's clear. If you-
Counsel, I'm sorry, you just stated you could have come in and asserted affirmative defenses. Correct me if I'm wrong, but the bank had obtained a default in May of 2010 against Miss Adams. Is that not correct?
If that's what the docket shows, and I guess.
Correct. So you couldn't have come in and asserted affirmative defenses because you take the litigation as you see it. The quitclaim deed was not, there was no quitclaim deed until April of 2012. So basically, at that point in time, the trial judge had a final judgment pending because the predecessor in interest, Miss Adams, had been defaulted 2 years before your client took a quitclaim deed.
I think it was a default, but I don't think there was a final judgment.
I understand, but the next step after a default, they were looking at a final judgment of foreclosure. You're coming in at that point to reopen the case because you just stated you wanted to file affirmative defenses.
Yes, but I think that you can also, before the court, there's procedural rights where you can ask the court to undo a default judgment under certain circumstances. But we can't even get there. If we can't even get to asking the court for affirmative relief under any of the rules afforded to the party, then it's simply improper to prevent us from intervention. We should have the opportunity to intervene, and then the court can make its ruling subsequent to any intervention rules.
Okay, thank you, Mr. Kline. We'll call you back up for rebuttal. Morning.
Good morning. May it please the court. I'm Kristen Cross, and I'm here on behalf of Deutsche Bank. And I think I wanted to start with a comment that Judge Perez made, which was whether we have a divergence of cases on this matter. And I'm really not sure that we do have a divergence of cases, because all of the cases referenced by the appellant are unrelated to foreclosure. All of the cases in Florida that relate to a foreclosure say that a pendente lite purchaser cannot intervene in a foreclosure action, and that's been the rule in Florida for over 100 years. That was already the rule when the Peninsular Naval Store, the seminal case in this matter, was decided, and the court recognized that intervention should generally be allowed if someone has an interest in the property, but the court said when there's a foreclosure action, it changes.
Why are foreclosure actions treated differently in terms of intervention?
I think because to protect the property interest that the mortgage company has, if you say in today's environment, even not going back to the 1800s, in today's environment, a mortgage company forecloses, well then the borrower just quitclaims the property to somebody else, and then they're allowed to intervene, and then that party could quitclaim the property to someone else, and they're allowed to intervene. I mean, at some point, you cut off the interest, and I think you protect the mortgage company and its interest. From a public policy perspective, I think it's important to protect that interest, because the mortgage company, that's all it has securing its loan to the borrower is its mortgage on the property. And if it's foreclosed.
The problem I have with your argument, though, is you're relying on old Supreme Court case law prior to Nelson Bullock, where the court discusses a new rule which eventually becomes the current rule. And the court seems to me to indicate that in equity cases, even though that was the rule previously, relying on that mortgage foreclosure case law saying you don't allow after a lis pendens, the rule changed that. But you're wanting us to rely on old Supreme Court case law, which I agree the third district has cited and to some extent arguably resurrected. But I can't explain why the third district didn't deal with Nelson Bullock. But it seems to me that Nelson Bullock clearly says we now have a rule that basically trumps the old premise we had that in a foreclosure suit, if there's a lis pendens, a purchaser pendent lien cannot intervene.
I think I understand your concern, and I would like to just point out, however, that Nelson Bullock is a quiet title action, and the court very specifically said in Nelson Bullock the sole question we are called on to answer is whether or not the intervener can intervene with a notice of lis pendens having been filed at the time the suit to quiet title was brought. So I think that perhaps Nelson Bullock addresses only the issue of quiet title, and it's not just the 3rd district, it's also this district, the 4th district in Seligman. I'll find the site for that. It's 781 Southern 2nd, 1159, was a divorce proceeding where a wife filed a lis pendens, and then the mortgage company could not foreclose because when it took the mortgage, the wife already had a lis pendens on the property. And in that case, this court said that the general rule is whoever purchases the subject matter of a suit, pendente lite, takes subject to the decree or the judgment. So I think even when you apply the two-prong test that everybody has applied, maybe the would-be intervener here has an interest, but then you get to the question of what interest do they have? They only have the same interest that the borrower had, which was the point that you made, Judge Perez. And then I think, have I answered your question about the Nelson Bullock case?
Well, my recollection is there's some language in the opinion that talks about equity proceedings generally, but
There is
I
some
understand
language.
your interpretation of the case to be limited to quiet title actions.
I would suggest that it's limited to quiet title actions, although I will admit that the language applies in equity actions. But we have the subsequent.
And mortgage foreclosure proceedings are equitable proceedings.
That is true. The other point I would make, though, is that it is an abuse of discretion standard in this case. So assuming you have divergent cases, then the question is, did the judge abuse his discretion?
I was going to ask you that. What factors weighed against allowing Lake Success to intervene in the foreclosure action? When the trial judge exercised its discretion in this matter, what factors did the trial court consider in not allowing intervention in this case?
I think the trial court relied on the case law that's cited in Deutsche Bank's opposition to the motion to intervene, which is the string of cases that say that there is no intervention in a mortgage foreclosure case if you took the property after the lis pendens was filed. And there were not any other factors presented to the court for consideration, as was discussed previously. There's no evidence as to how or why Lake Success took a quitclaim deed to the property. We just don't know any of the circumstances related to that transaction because no evidence was presented to the court regarding that transaction. And it's difficult to decide the court wouldn't have had any factors to consider. It's difficult to evaluate what factors the court considered when there weren't any evidentiary factors presented to the court.
In terms of, having an adequate record on appeal, do you think it's significant that appellant did not include in the record a copy of the quitclaim deed?
I've seen the quitclaim deed. I know it was recorded.
So there's no dispute
So there's no
about
dispute that the quitclaim deed exists. I think the bigger problem is the lack of any evidence regarding the circumstances under which the quitclaim deed was executed. But even if there were such evidence, I think it's hard to say that the trial court abused its discretion. And we talk about the abuse of discretion standard a lot. And then if you look at what it really means, though, it says this is Kanakaris v. Kanakaris. This is 382 Southern 2nd, 1197, and it explains abuse of discretion this way. It says, if reasonable men could differ as to the propriety of the action taken by the trial court, then it cannot be said that the trial court abused its discretion. So I think even if you assume that the cases are divergent, which again, I think the cases are not, that it's clear that in a foreclosure case, the rule is different. But if you assume they are divergent, then can you really say that reasonable men could not disagree on the trial court's decision? I think reasonable men, maybe could disagree on the trial court's decision, which is why we're here today, I guess. But I think it's very hard to say that the trial judge abused his discretion. And if the court doesn't have any questions for me, thank you.
Thank you. Great, Mr. Kline, you don't have a lot of time left, but you do have a full minute and 11 seconds to wrap it up.
Thank you. The pendente lightless pendens test is the old rule. The new rule is the rule, 1.230, which came from the Nelson v. Bullock case, the rule that was cited, which is the old rule. But for 85 years, it's identical. They haven't changed the rule. It says anyone claiming an interest in litigation may at any time be permitted to assert a right by intervention.
Well, what about counsel's argument? When you have a quiet title action, you are the new holder of that title. So your interest is at stake. In the foreclosure context, that bank usually has priority over everyone. So when you because if we were to accept the argument you just made right now, there is no reason for a lis pendens.
No, there is a reason, because it puts parties on
Notice that there's litigation.
Right, but it still doesn't prevent intervention. And as a matter of fact, the courts have even granted intervention post-judgment. You're limited as to what you can do post-judgment, but courts have even granted intervention post-judgment. It's a very liberal rule. The intervention rule is very liberal.
And if you, and again, if you were to tell us what it is that you wanted to intervene for, because I'm sure that this was presented to the trial court. The trial court probably had a question. What is it that you want to intervene for? If your answer was to raise affirmative defenses, as you told us today, just given the record as where the case stood, the trial court may have thought, listen, this case has been pending for 2 years. The bank has been waiting on its foreclosure. The original owner was defaulted. You have only the rights that that person had. So you're in a defaulted position, and there's no of course you can't file a motion to vacate the judgment until after he allows you to intervene.
Correct.
He may have thought, this is too little too late. You bought subject to the default was also a matter of public record. You could have gone to the courthouse, checked where the litigation was, and you took it at the risk.
You still have rights, whatever those rights are. You still have rights, and you can assert those
What are
before
they?
the court. Rights, motion post-judgment relief under 1.540, 1, 2, 3, and 4, and 5. There's a whole rule of civil procedure for post-judgment relief on default to set aside courts' orders on that were previously entered. You have motion for reconsideration that could have been for previously ruled on issues that could be re-raised.
And you could have, if you had any of those and raised it to the trial court, he may have allowed it. But I don't think that there was anything raised at the trial level which in the mind of that judge presented anything except we're delaying now this on something that can't be brought forward.
The court can't rule until, one, we intervene in the action, and then we raise the issues. You have to have intervention. You have to have step one to get to step two.
Okay.
Thank you.
All right, if there's nothing further, thank you very much.
Thank you for your time.
The court will be in recess.